than that, we can start taking questions on Hindustan Corporation, and then we can move on to, let's say, maybe Perkins, Eastman.
I think some questions have come. Anubhab, somebody has put questions in the chat box if you see. Okay. I think one question is for me. I'll just read it. Somebody has asked me, can you throw some light on the manifest? Just check what the question is. Just give me a second. Hi, Tariq sir, could you throw some light on the doctrine manifest arbitrariness under Article 14? And then the other question is, Anubhab sir and Tariq sir, my name is Dhruv and I'm second year so-and-so. Justice Nariman also said in this regard that India cannot become a hub of arbitration. If it goes on like this, could you please elaborate on that? Okay, so these two questions. Okay, I'll just briefly tell you and then Anubhab can also answer on the same questions. Anubhab, can you see the chat box?
Yeah, I can. Go.
Yeah, so I mean, briefly, I'll tell you manifestly arbitrary in the sense that any state action which is arbitrary and which is not in the, I mean, if you feel that, because the legislature at the end of the day, the concept of automatic stay, like I told you. So what Justice Nariman projected was that automatic stay is in a way draconian law for the award holder, for somebody who is having the award in his favor, and he is deprived of the benefits, the fruits of the award. And for that reason, it is in a way manifestly arbitrary. And that is the context in which the councils also argued the same, because it is in a way oppressive state action. It is not something which is required because there is no vested interest of a judgment debtor in resisting execution. And the other question that has been asked, what Justice Nariman said, that if this goes on, then India cannot become a hub of arbitration. See, the reason, like I told you, that after the 1996 amendment, 1940 Act was replaced by 1996 Act to make India more investment friendly. Similarly, 2015 amendments were also brought for this purpose. The reason for making India a hub of arbitration is because more and more investment in the country and making India the place where, as an investor, I would want to see how the courts deal with the awards. If the courts are interfering way too much, I would not want to invest in any country where the courts are not arbitration friendly. They are not dealing with 34s and, execution is a task. So I think these are the reasons why he said that if automatic stay is not removed and if it's not applicable on the pending arbitrations, then a wrong message will go internationally. Yes, Anubhab, over to you.
Yeah. So I just, rightly so, to answer Dhruv's question, in addition to what Tariq said, that's exactly the case, right? Now imagine you are an investor coming, you're an investing company holding a holding company of a company in India. Now, in the sense that, or you're directly investing in India per se, and and of course you come under the aegis of international commercial arbitration, where you get an award in your favor in a dispute arising out of with another Indian party. And what happens is that while you go to exercise your right to enforce the award, what happens is that your award is stayed. Okay, then it is absolutely counterproductive to the whole idea of entering into an arbitration agreement, settling it by arbitration. Okay, and then because if you will notice that in throughout the course of arbitration, there is more than enough hindrances that you can have. Okay, like which an opposite party can have. Once you've admitted to the jurisdiction of the arbitrators, also there are various stalling procedures you can have. Like you can approach the court in various measures. Okay, now after going through all of these hindrances, let's say section 17s and all of that, after going through all of these hindrances, when you finally get an award, and that is also stayed, it's counterproductive. Why will people come to arbitrate then? People will directly try to exercise its right under court jurisdiction, which is even counterproductive. But so that it just not work out. So that is why Mr. Nariman rightly pointed out that Justice Nariman rightly pointed out that India will never be able to become a hub of arbitration in India. And in my limited experience that I've seen, Justice Nariman is the most pro-arbitration person that there is in the Supreme Court in my 5-6 years of practice that I've seen. Primarily because even if there is a small lacunae between what is written in the law and something which is logically interpretable and is pro arbitration, he will always go for the latter. So that is one of the main reasons, and I think I welcome the decision.
Anubhab, I think there are 1 or 2 more questions if you would like to answer regarding 87. Can you use the chat box?
I think it's come to you. Okay, no, I think Mohit has sent it to me.
Yeah, Mohit has sent.
Okay.
Too many questions.
Yeah, actually. These are all section 87 questions. Yeah, so would you want to take them, Tariq?
Yeah, I'll just briefly, because there are 7-8 questions.
Yeah, so I think they can be clubbed into as one.
Yeah.
So that's what I'm trying to do.
Yes, the question is that 87 is an exercise of colorable legislation. Then there's another question that, could you point out the relevance of section 26? Is it possible that legislature will try to counter this judicial check and this tussle between legislature and judiciary will continue, or will take it in the right stride? So these are I was reading an article which talked of relative implication of the 2019 Act and mentioned that 29 is prospective not only to arbitration proceedings, but related court proceedings. Section 87 was so and so. I agree with you, understand of Nariman's judgment. Is it not judicial overreach? See, I'll just sum up. I asked the same question to the then Chief Justice of Delhi High Court in one of the conferences. I mean, I'll just club all of this regarding the Section 87. This was an ICC conference where I got up and I asked this question, that when the legislature, because Section 26, if you read of the 2015 Amendment Act, which said that the Act would be prospective and it will be applicable after 23rd October 2015. The bottom line is, see, the same thing was answered by Justice B.D. Ahmed. He said, it's a good piece of law. The judgment is really good and arbitration friendly. At the end of the day, what Supreme Court is trying to achieve is that they are trying to make India as the hub of arbitration. The steps are being taken. And they're trying to be more decree holder friendly. So that if someone gets an award, because at the end of the day, the scheme of the Act is to resolve a dispute expeditiously, unlike the courts. Because if a Section 34 is filed, just imagine, I mean, I'm just being practical, the difficulties that we face. So if I have an award in my favor, and if somebody has challenged it, and if I do not get the benefit of the amendment, then there is an automatic stay on my award. I can't get the fruits. 34 will go on for 3 years, 2 years, 4 years. I don't know how much time. If you have been to courts, you know how much time it takes. Then there is an appeal under Section 37. That will take another 1 year, 2 years. Then Supreme Court, that may take another year. So if I'm getting even though the Act says that arbitration should be finished within a year's time. Now after the amendment, they have made it 6 months for pleadings and 12 months for the pronouncement of award, which makes it 1.5 years. So arbitration is finishing within 1.5 years, and you are getting your money after 5 years, 6 years, or maybe not. So, I mean, there may be cases of colorable legislation. You may say that legislature has tried to do something, by exercising its power in colorable manner. But at the end of the day, the legislature did try to overturn, that's my personal view. They tried to overturn the judgment of BCCI because it was based on, Section 87 was based on Sri Krishna Committee report. And there was no mention of Justice Nariman's judgment of BCCI. I think ethically that should have been considered in view of the fact that Justice Nariman had marked a copy to the Law Ministry as well as to the Learned Attorney General. But there was no mention of the judgment at all in the Section 87. And the other problem which Justice Nariman pointed out in the Section 87 was that it is based on Sri Krishna Committee report, which does not consider the IBC, Insolvency and Bankruptcy Code. And that was the major issue. Because the example that I gave you, if I have an award in my favor of 1,000 crores and I cannot get the money, then Anubhab or anybody else whom I have to give 1 lakh rupees or plus that, then that person can take me to the insolvency and bankruptcy and get a moratorium issued against me, even though I have a positive 1,000 crore award pending. So that was the logic which was given, and Sri Krishna Committee did not consider this.
Correct.
Insofar as, yes. And insofar as judicial overreach and articles that you are referring to, so every author has his or her own opinion. Many people may say that at the end of the day, the Supreme Court has extraordinary powers; they can do what they want. But I think personally, it's a very positive step. It was much needed, because there is no reason for an automatic stay, even on the pending matters. Because getting rid of the automatic stay was, I think, the need of the hour.
Just to Aditya's question, has the HCC judgment nipped the era of automatic stay in the bud for good, or is there's still a need for clarity on the matter? I mean, from my experience, what I understand is that there is always a chance of deliberation, even when we have seen issues being considered with finality. But so on and so far, in the present circumstances, I feel that the judgment provided in HCC is quite conclusive. It has tried to maintain the relationship with the legislature in like striking a proper balance. I think the judiciary is tried to exercise its balance in a proper manner. It's tried to just try to maintain a healthy balance. And having said that, in these circumstances, if you read the judgment also, the decision and the reasoning given by the learned councils and the decorum taken by the learned councils and of Justice Nariman in the judgment is quite conclusive. Okay, I don't see this being debated and being overturned unless a very extenuating circumstance comes into the picture in relation to this. I think, in my opinion, it's quite conclusive. Tariq can have his opinion known, but in my opinion, it's quite conclusive.
Yeah, I completely agree, because and the fact is that we are running short of time and we have to cover judgments. But I will just say this, that yes, it is conclusive, and I don't think legislature is going to play this game again that they come up with another amendment. I think the debate has finally settled, and the law as it stands today is that the 36(2) is applicable even on pending matters. And one question which came from somebody regarding CPC, the order so and so of CPC, could you throw some light? So yes, 87, basically what Justice Nariman meant was that any decree of civil court, the way it is executed and the way there is stay on that, because what generally happens is that the court asks you to deposit and put certain conditions on you if you are seeking a stay on the execution. So same thing, he said that if you are executing an arbitration award, then it will be treated as a decree of the civil court, and same rules will apply, which means that the court some security has to be deposited for staying the operation of the award, just in case, the way it is done in civil court in respect of decrees. Now coming to the second judgment quickly, because I think you're running short of time, you're running against it.
We will, let us start with Perkins Eastman Architects DPC versus another. So I'll start with that, Tariq, and then you can maybe take it on from certain issues.
Absolutely.
Okay, yeah. So, well, again, this was, again, a very recent judgment, okay? And this again deals with this very separate issue in terms of the Arbitration and Conciliation Act. What it deals with is essentially, if I may break it down, two broad areas under Section 11(6) of the Arbitration and Conciliation Act, or broadly Section 11, which essentially deals with the appointment of arbitrators. This case law essentially deals with two essential broad points, which says appointment of arbitrator by one party or their officers and employees. Secondly, what it dealt with was whether the Supreme Court can exercise its power under Section 11 when an arbitrator has already been appointed. Okay. Now, before we, these are the broad issues, and after that, what we are going to discuss. So, I mean, there was some other lawyer which was appearing on behalf of the applicant, and for the respondent, Guru Krishna Dutt appeared, if I'm not wrong. And the issues, the broad discussions during this judgment were based on the point of whether there was impartiality, whether there was whether you could throw any aspersions on the impartiality and independence of the arbitrator. Secondly, what we dealt with was whether this whole dispute fell under the ambit of international arbitration, because the Supreme Court under 11(6) only had the discretion to appoint arbitrators in the event it was international arbitration under the definition of international arbitration, which is a separate topic altogether. And what are the inherent power Supreme Court under Section 11 of the Arbitration and Conciliation Act. Now, before we get into what are the issues and what were the discussions subsequently, I would like to discuss the facts in brief. So what led to this dispute was essentially a faulty arbitration clause in my opinion, because if anybody has ever interned in an arbitration chamber, or if you've been a part, or if you've seen any old PSU arbitration contracts, when I say PSU, I mean public sector enterprise contracts, just to specify. You will see that these PSU contracts are extremely one-sided in terms of implementation, enforcement. Okay, there has been several judgments in terms of domestic arbitration, but when we are dealing with, let's say, international arbitrations, the understanding in relation to, so why I said there's a reference between PSU contracts, and this is primarily because of its arbitrability, arbitrariness in terms of appointment of arbitrators. The PSU contracts, which I have often seen, used to have a notion that the arbitrators will be appointed, let's say, by the matter will be arbitrated by either a key managerial person of that company, or the sole arbitrator will be appointed by a key managerial person of that company. Now, what it does is inherently gives the power to one party to the dispute to either arbitrate the dispute or appoint an arbitrator to the dispute. Okay. In terms of domestic arbitration, it has been dealt with in several instances, but here we are dealing with an international arbitration. So I will just come to the point why in perspective of this case, this issue is important. A contract was entered into between the consortium of applicants. The applicants came together as a consortium, okay, a group of companies. So Eastman, Perkins, Perkins, Eastman Architects, DPC, and other companies which might also have had companies registered in India. However, the main focal point of the company, of the consortium employees, was the Perkins Eastman Architects in New York, United States of America. They entered into a contract with Hospital Services Consultancy Limited. The contract contained a very elaborate dispute resolution clause, and the main crux of the dispute resolution clause stated that any dispute or differences shall be referred to a sole arbitrator, and the sole arbitrator will be appointed by the chief managing director of the respondent company. And such appointment will need to be made within a period of 30 days from the receipt of the request of the arbitration. Okay. Now, the applicant called upon the chief managing director, based on this arbitration clause, called upon the chief managing director of the respondent to appoint a sole arbitrator in the dispute on let's say about on a certain date, and the applicant stated during this proceeding that no arbitrator was appointed for the next 30 days. On 2 days after the lapse of those 30-day period, the chief general manager addressed a letter and appointed a sole arbitrator in this given instance. So the applicant consortium contested this appointment on 2 grounds. Essentially, that there was a delay in appointment of the sole arbitrator, okay, and subsequently it also said that the requirement of it was not independent and impartial. That means the appointment of the sole arbitrator was not independent and impartial, okay, under section, and they moved an application to the Supreme Court to appoint an arbitrator under section 11 clause 6 of the Arbitration and Conciliation Act. Now, prima facie, on perusal of these issues, you can always say that it seems like the applicant has come here with an afterthought, because you have requested, you've done your obligation to the part of the arbitration clause, and you have requested, as per the determination of the arbitration clause, to go forward and appoint an arbitrator. And now you're saying that no, the procedure of appointment of arbitrator is ipso facto not conclusive with the ages of law, and that's why we should be moving until 11.6. And also we are saying that there was a delay in appointment of the arbitrator. While dealing with this, I think it was a bench of Tariq, correct me if I'm wrong, it was a bench of Indu Malhotra and
Vijay Lalit, Justice Vijay Lalit.
Yeah. These two judges. Okay, and now the question of impartiality and independence came into the forefront. Now, when we determine whether the impartiality or of the arbitrator, okay, there are the provisions that come into feature as Section 12 of the Arbitration Act, which essentially are read along with, of course, the 5th and the 7th schedule of the Arbitration Act. But the Section 12 essentially narrows down that the grounds under which you can challenge an arbitrator. And subsequently, when you read Section 12 clause 5 along with Section the 5th and the 7th schedule, okay, you can come into a consensus. 5th schedule gives you some qualifications, okay, as to circumstances which gives as to what are justifiable doubts in relation to the appointment of an arbitrator, whereas the 7th schedule would give you what relationships or if the arbitrator would be ineligible to be appointed under the present relationship structure between, or the correlation between the parties. Okay. Now, dealing with this question, the main question which came into the front was if the chief managing director could not have been the arbitrator himself, okay, could he legally exercise his authority to appoint a sole arbitrator? Okay. So the court considered that in this situation, the respondent argued that in the present dispute, he was supposed to appoint an arbitrator, okay, because the express provision of the arbitration clause did not say that the chief managing director would act as the arbitrator. Because and now I would draw reference to the PSU contracts. If you look at the national thermal power contracts, the NHIA contracts, you will see that the arbitration clause says that somebody in the key managerial positions in those entities would serve as an arbitrator. Because and they laid their arguments on the garb that these are very technical arbitrations and you would need a person of adequate technical expertise to oversee these arbitrations. And under those garbs, it used to be extremely one-sided appointment procedure for appointment of arbitrators. Now, in the present dispute, the arbitration clause expressly provided that the chief managing director could not be the sole arbitrator. However, he was given the discretion to appoint an arbitrator in this case. So, in this situation, I think we have to go back to another very landmark judgment. It was TRF versus Energo, okay, which the court very lightly considered in this case. And the court said that TRF was concerned, in TRF, the managing director of the company, the arbitration clause in this judgment, TRF versus Energo, clearly said that the managing director was either to appoint as a managing director, as an arbitrator, or appoint a sole arbitrator. Okay. The Supreme Court in TRF held that the managing director could not have acted as an arbitrator. He could not have appointed an arbitrator either, simply applying the principle that what can't be done directly can't be done indirectly. And this is one of the underlying principles on which this case law also proceeds. Okay. Now, what we see during the discussions that follow in this judgment is very interesting, primarily because there are so many varied areas of law that was taken into consideration. Like Tariq pointed out in the last judgment, there was also an IBC angle to it. In this judgment, why I feel it's very important, because impartiality is in itself a discussion for another day, because people can discuss that through a day. So now the question before the court was that, in this situation, the court distinguished the facts from the judgment that it discussed and said that the Energo decision is practically very different from in this. Okay. So the Supreme Court concluded in this judgment that the issue, whether there is justifiable doubts in relation to whether the person nominated by the chief managing director is present or not, would warrant an appointment, and it would bring into a situation which might disturb the balance between both the parties. Like if I am a party and if I am an invested party in the arbitration, okay, if I have interest in the arbitration, okay, I cannot be given the providence to appoint a sole arbitrator. And that is against the main ethos of arbitration. The main ethos of arbitration being party autonomy, equity of justice, and so on and so forth. So based on that, the Supreme Court in this discussion considered the very fact that appointment under these provisions of a sole arbitrator by the chief managing director was not in recourse of indirect provisions of law. Now moving into the aspect of whether 11.6 could be applicable, because application of 11.6 also requires certain direct tests, in the sense that the appointment of the appointment of the arbitrator should, if the appointment of the director is ex facie not illegible or seems illegal, then the Supreme Court can't in this situation intervene and exercises power under 11.6 to appoint an arbitrator. So that was also a question that the Supreme Court wanted to consider. The Supreme Court in this situation wanted to consider the case AG, Walter Bow AG versus the Municipal Corporation of Greater Mumbai. And it said that unless the appointment of the arbitrator is ex facie valid and such appointment satisfy the court's acceptance of such appointment as ousting jurisdiction under 11.6 cannot be sustained in law. To simply, if I can explain it to you, the appointment must be valid on the face of it, and the must satisfy the court exercising the jurisdiction under section 11.6 of the section 11.6. That means the appointment that you're doing should satisfy the basic tenets of 11.6. If it does not satisfy the tenets of 11.6, an application under 11.6 will be applicable. Okay. While discussing this, the Supreme Court also considered the case of Precol versus Johnson Controls, and it distinguished its present state, the situation of the present case, with Precol. Okay. Why was Precol, which was of course proposed by the applicants or by the respondents, differentiated from this case, was primarily because not only was there an appointment of the arbitrator, but the parties had already admitted to the jurisdiction of the tribunal. So the Supreme Court in that situation had said, in referring to this case, said that once you've already admitted to the jurisdiction of a tribunal, challenging the tribunal is not under the tenets of basic practice of law. You have other measures that you can go under. You can go under 16, you can go on 16 and 34, you can go under other tenets of law that is applicable to you. And lastly, the issue that came, so basically on this issue, it was admitted. And lastly, the issue came under was whether this formulated an issue under the aegis of international commercial arbitration. So for basically the Supreme Court to appoint an arbitrator under 11.6, read with 11.12a, what it needs to do is that the arbitration needs to be constituted under a part of international commercial arbitration. So the Supreme Court observed that the application, though is a consortium, in accordance with the consortium agreement that was in place, one of the invested parties, the main invested party in this arbitration was that of Perkins, Eastman, which was the foreign registered entity in New York. And therefore, if it was a focal point of the arbitrator, there was no requirement to even consider whether whether it was an international arbitration or not. So under these aegis, it also considered that it was an international arbitration, and it considered other cases. What it clarified in terms of law was that it clarified three positions. First, that a person who is ineligible to act as an arbitrator cannot also appoint an arbitrator. So in simple language, the chief managing director in this situation would have created a direct bias under section 12, read with schedule 5 and 7, if he would have to act as an arbitrator in this case. Given that situation, if he can't act as an arbitrator also, he can't be eligible to appoint an arbitrator as well. That was one understanding that the Supreme Court gave in this situation. The second was that the court had the power to intervene in appointment of an arbitrator under Section 11 unless the appointment on the face of it seemed valid. Okay. Now, to interpret this whether that the court had the power to intervene under 11 in the event the appointment on the face of it did not seem fine, we have to go back to the first conclusion that we drew that the arbitrator cannot, the person who can't act as an arbitrator cannot appoint an arbitrator. So based on this understanding, okay, if you can't appoint an arbitrator, okay, that means if you can't act as an arbitrator, you can't appoint an arbitrator. That means the appointment and the arbitration clauses seems a bit murky in these grounds. So that means it's not clean on the face of it. And that's why the Supreme Court came to the conclusion that under 11.6, it can intervene. And thirdly, it arriving at these two conclusions, the Supreme Court laid down that it would come under the scope of international arbitration, and therefore the final conclusion that the Supreme Court in this whole judgment that it came to was that when two parties are involved in an arbitration, the balance between both the parties in terms of justice and equity is foremost. Okay? The appointment of arbitrator is one of the first steps of entering into an understanding proceeding into an alternate dispute resolution. Okay? Given this understanding, in the event that we provide the other party with a position of bias, position of unfair advantage, in such a situation, we would be giving rise to a situation which would not be fair and would be against the aegis of the basic tenets of arbitration. So given that, it said that a person who is directly invested in the outcome of an arbitration or invested in the decision of the arbitration should not have the power to appoint a sole arbitrator. And it does not reflect the practices outside of countries who we reciprocate laws with, or let's say the UNCITRAL model law. So based on this discussion, this was the final conclusion that the Supreme Court came at. Yeah. So, I mean, in relation to this judgment also, so what we discussed so far is that we so far discussed two very important recent judgments. One on, prospective and predated amendment on whether on the stay of a challenge of an award. And secondly, what we discussed was appointment of an arbitrator, which is ex facie in nature, which is unconstitutional in nature on the face of it. Okay, and how the Supreme Court said that bias needs to be done away with to create a balance between the entities. Okay? So based on these, we will open the floor again to some questions, and then we will move to the last judgment that we have for today.
I think there are two questions which have already come while you were speaking.
Yeah. Okay.
Do you want me to address?
Or
you want to take these questions?
You can go for it. I have no problem. Go for it.
Okay. One question is, I think somebody has asked, I'll just check the name of this person. I think Kajal, okay. So Kajal has asked a question regarding the first preliminary issue involved in the matter, which was that because there was a consortium involved, so whether this will be an international arbitration or not. So, and whether the Supreme Court will have jurisdiction to entertain Section 11 or not. So the court simply said that when you see the lead member of a consortium, if that lead member is a foreign entity, then this will be considered as an international arbitration. So that's how the Supreme Court simply said and decided the first preliminary issue. The second question which has come is regarding that, don't you think, Jodh Swaroop is asking a question that, don't you think this judgment in a way is against the freedom of parties, the party autonomy? So, so the answer to this, I mean, this has been discussed in previous cases also, but the answer is very simple. I mean, all the foreign philosophers, and if you see the arbitration experts worldwide, they have said that party autonomy means freedom of parties and not freedom of a party. Meaning thereby that even if I signed an agreement with an entity, and at that time I didn't have a bargaining power, so later on it cannot be said that, look, I'm imposing my guy, somebody who works for me, as the arbitrator. That's precisely what, and in a way, the judgments of Perkins Eastman is in line with Schedule 7 and Schedule 5, which were added to Section 12 by the amendment of 2015. It simply says that if somebody is an interested party, they are your employee, then they cannot be the arbitrator in the case, because you don't bite the hand that feeds you. So any arbitrator who has been appointed by a company will not obviously pass an award against them. So that was, but the larger issue which involves, which is in this case, is regarding the panel of arbitrators, because the judgment simply says that in case of a sole arbitrator, when there is a case of sole arbitrator, then a party must not appoint if it is interested in the dispute. But the larger issue is, because if you see the other judgment, Voestel Fine judgment, wherein the discussion was regarding the panel of arbitrators.
Correct.
That if the employer is maintaining a panel of arbitrators and giving you an option to choose from it, then that is valid. That is not invalid. That is not said to be against the Arbitration Act. But again, the issue arises that how many people should be there in the panel. The issue in Voestel Fine judgment was 4. Initially, there were 4 members who were nominated. The court said, no, this is not broad. We are directing all the employers, all the PSUs to keep and maintain a wide panel of arbitrators from which the other side can choose. So that's another issue. I don't know if anybody is going to ask. Yeah.
Yeah, that's it. Guys, I mean, it's my request. Just to maybe all these contracts are available online. So if you go to let's say NHI or anything, if you just pull out just any of their contracts and see the arbitration clause, even like pre-2000 or like between 2000 to 2005 also, you will see the arbitration clause, and you will see that while I understand that party autonomy is a big feature, but party autonomy is based on natural principles of natural justice. You can't defy principles of natural justice and then cry party autonomy. Party autonomy, you can't cry party autonomy for something which is voidable in law. Correct. So based on that only, the idea is that, I mean, let's just break it down. Let's say Tariq and I are in a dispute. I can't say that, you know what, my mother will be the arbitrator in this case. Like, it just does not work out. Like, yeah, that's the whole idea behind it. Okay. And especially when it's in international arbitration. Okay. When the court considers this to be an international arbitration, because of one of the most invested party is an international organization, it does not reflect well on the arbitration environment in India. And that is where we come back to the last judgment that we discussed, whether India can become a pro-arbitration arena or not. And if practices like this go on to be evolving, then we will never become a pro-arbitration area where it's a direct thing that, you know, like the country incorporated in India has the direct right to appoint the sole arbitrator. That's absolutely against the tenets of natural justice. So that is something we have to consider. Which question did we stop in?
I think there's one more question Jotsarup has asked. I'll just simply tell you what are the practical implications of Perkins regarding interference by courts. So there was a judgment recently by Delhi High Court called Prodhatur Cable. This is OMPT Commercial 109 of 2019. So in this case, a very interesting question came up, whether Perkins will be applicable on the pending arbitrations or not. So the court said, yes, it will be applicable on the pending arbitrations also. And now, if it is applying to ongoing arbitrations which had been initiated under the 2015 amendment. So now the scene is this. For instance, there was an arbitration which was going on or was at any stage. And after this judgment, now the arbitrator, if he was unilaterally appointed by an interested party, then he also becomes ineligible. So in a way, this judgment is being applied by the court retrospectively. So even at the stage of execution, perhaps an award can be set aside on this ground by using this judgment. So it's very crucial.
Correct.
Read this judgment if you want. It's OMP T Commercial 109 of 2019. Prodhatur Cable, PRODDATUR Cable. Prodhatur Cable versus Digi Services. It's a very, very interesting judgment. Applying the future of, you'll get to know how Perkins is to be implemented now. Okay, are we going to discuss the third judgment? Because I think we are running against the clock, like I said, and perhaps we have exceeded the time. If there is time and if people are interested, then we can cover the third judgment also briefly.
Yeah.
I think what we can do is we can start with the discussion on BGS Soma. Perhaps like keep it limited, like our Anubhab sir was pointing out, and keep it restricted rather than venturing into its implications on seat. Keep it restricted to the discussion with respect to what will be its implication insofar as India's arbitration stance is concerned and its image is concerned. Perhaps we could have a discussion on that. Keep it restricted.
Somebody has asked me a question. Just one second.
Sure.
Repeat the name of the case. Okay, I'll just mention the name of the.
Write it down here. We'll send it to Mohit or something like that. We can write.
Yeah, we'll. Any of these things you want, you can always ask me, Anubhab, or anybody. Yeah. But the name of the case is Prodatur Cable. PRODDATUR Prodatur Cable. The moment you write Prodatur Cable, it's a judgment by Justice Jyoti Singh. It's OMP T Commercial 109 of 2019. It's a very, very important judgment. Read it. Or otherwise, just let me know. I'll share it. So should we like briefly, Anubhab, you want to go ahead or you want me to briefly?
Yeah, what we can do is that we can just mention the principle of on which like, you know, BSS, SGS, Soma is based on. And then maybe let me just lay out the principle, and then you can just go into, you know, the basically the implications of the judgment later
on. Okay.
That sounds good?
Yeah, great.
Yeah, fantastic. So again, this was a 2019 December decision of the Supreme Court, if I'm not wrong. Tariq, this was December only, right?
Yes. 10th December.
Yeah, 10th December, yeah. And BGS SGS Soma versus NHPC Limited. So now, while this case like discusses various points, okay, one of the major discussions against this case law is against whether certain basic tenets of law has been followed while the court arrived at its decision, or whether the Supreme Court in this decision was punching above its weight. But not digressing, the main issue that the court was deciding was whether a designation of seat, okay, confers exclusive jurisdiction on the courts of the said seat, and a place of arbitration, regardless of its designation as a seat, venue or place, is to be considered as the juridical seat of the arbitration unless there is an understanding in contrary. Okay. So while discussing this point of law, the Supreme Court considered the decision in I think Hardy Exploration versus Hardy Exploration, and it said that that law is not good in law, and following which it struck down that judgment. Now, it basically said that the venue of the arbitration, which is designated in the arbitration agreement between the parties, is basically the seat of the arbitration. This is where we come to the discussion of seat and venue. Okay. When we learn arbitration, what we learn is that seat is, of course, has implication in terms with jurisdiction. Okay. This is what we learned. I'm not getting into the details in vision. Seat has implications in terms of jurisdiction, operation of law, so on and so forth. Venue is merely a location where it arbitrates. But there has been a genesis in this understanding. Okay. And this judgment goes on to say merely that the venue of an arbitration designated in the arbitration agreement between the parties is really the seat of the arbitral proceedings. So this is what this point of law it discusses. So its implication is manifold in my opinion, primarily because the implications, one of them is whether the Supreme Court in its decision, basically considered Balco and said that, you know, it goes against the 5-judge decision of Balco, and that's why this the Hardy Exploration judgment is not good in law, and therefore this should be the present stance in relation to this issue. But what we need to consider is that other than the point of law discussed here, in terms of implication, did the Supreme Court punch above its weight in terms of, let's say, the principle of stare decisis, or let's say the value of precedence and so on and so forth. So maybe Tariq, if you would want to take up from that, and then we can discuss the whole criticism of this judgment. If
Yeah. So I'll just tell you two, three. There's one question, in fact, which has come from Mohit, that between Hardy and BGS SGS Soma ratio, which one will take priority? See, both judgments are same bench, and it cannot be that the same bench can overrule. So what the observation in BGS SGS Soma is, Justice Nariman says that the reasoning given in Hardy exploration and in Antrix, Devas versus Antrix, these are two judgments which were involved. He said that is not the correct position and that is bad law. Why? Because it doesn't follow the 5-judge bench judgment in Balco, and it does not apply the. There was a test, I think. I am forgetting the name of that test, which was discussed in Balco, Soshua test. And what this judgment BGS SGS Soma, there was one issue which I forgot to mention. There was a 34 which was filed by NHPC in Faridabad in this case, and the arbitration took place in Delhi completely, all the hearings, and it was not mentioned what Delhi is, the seat or venue, and the award was also signed in Delhi, New Delhi. So when the award was challenged by NHPC, because NHPC lost, and this was a joint venture, JV, BGS SGS Soma, they were the winning party. So this section 34, when it was filed, an objection was taken up that this court will not have the jurisdiction because everything happened in Delhi. And therefore, this order of 34, where the matter was transferred, was challenged. This transfer of 34 petition was challenged in Punjab and Haryana court under section 37. So the issue was whether an order of transfer, basically simply transferring a 34 case from one city to other, whether this is appealable under section 37 or not. So the Supreme Court, so even though Punjab and Haryana High Court said yes, it is appealable, but the Supreme Court said no. 37 clearly says that appeal shall lie from the following and none other. So because a decision on a transfer of a petition is not covered under section 37, therefore it will not be appealable because it is simply a transfer from one city to another. The second thing which Anubhab pointed out, the second issue was what is the significance of a venue. So Hardy basically said venue plus concomitant factors is equal to seat. So venue alone will not be treated as seat, but venue coupled with some concomitant factors will be treated as the seat of arbitration. And why seat is relevant? Because the seat determines the exclusive jurisdiction of the court. So seat is the epicenter of an arbitration. So if the seat is Delhi, which means that courts in Delhi will have the jurisdiction. That's why seat is so relatable and so important. Justice Nariman said that if seat is not mentioned, and if there is only a venue given, then sometimes place and venue, seat, these are used interchangeably. So unless there is anything significant which suggests otherwise, even the place will be treated as the seat, and the courts will have the exclusive jurisdiction. And eventually, the court held that not Faridabad, it will be Delhi, because the award was signed and the venue was Delhi. Therefore, the petition would lie in Delhi, any challenge to an award. So that was the long and short of this judgment. Now we can have a questions. If anybody wants, we can unmute. Don't you think that concept of seat and venue have wider ramifications in international arbitrations? Can we say that Hardy is good law? Yeah, it will have wider interpretation. I think that the reasoning given by Justice Nariman is, I think, personally, it's a better view adopted, because Hardy was not a bad law. The concept of seat has been going on for a very long time. We started from Indus judgment, then we came to Antrix, Devas, then Hardy, and now finally this. Let's see, maybe this issue will be referred to a larger bench, and finally the law will be settled. Seat and venue. So like I said, if the seat is specified, so difference between seat and venue, what are the factors coupled with the venue to make it a seat? So now the way the law stands, I'll read it for you what Justice Nariman said. He said that designation of a seat confers exclusive jurisdictions on the court. So if the seat is defined, you don't have to look at anything else. If the seat is given in an arbitration clause, then that means the courts of that seat will have jurisdiction, exclusive jurisdiction. The debate ends there. However, if the seat is not mentioned, then what it says place of arbitration is the juridical seat of arbitration unless there is an indication to the contrary. So the place will be treated as a seat if seat has not been specified, unless there is anything significant which suggests contrary, that no, this should not be the seat. So
yeah. So like this is again going back to the basics of understanding. So like from the person who I learned arbitration from, Professor Hunter always used to say that seat and venue are the basic two tenets. Venue can be a vacation also. Okay, a venue is essentially can be a vacation, but this always like has given rise to all sorts of confusion. Okay, because when parties enter into a contract, they often don't take into consideration a lot of legal implications of the contract that has been drafted. Okay, I've had arbitration like contracts come to me which has arbitration clauses, and I have said that like this is absolutely goes against us, and who's drafted this? The clients go on to say that yeah, we pulled it out from the internet and we put it through. So this is the practice in India, because a lot of the contracts we get, I don't know, like Tariq can maybe differ from that, but a lot of contracts I have gotten, like high stake contracts, they've just been like copy pasted by some employee in the office, having no understanding of the implication of what it might give. So that is where the debate of seat and venue comes in. Otherwise, the concept of seat and venue is very clear. Okay, that you define what is seat and you define what is like venue can be anything. Venue is the location. Venue, the travo preparato of and the concept of venue is basically for the comes from the concept of international arbitration. It has been absorbed into domestic arbitration. Why it is a concept emanating from international arbitration is because you have lawyers from different countries coming and fighting a dispute, arbitrators from another country. Okay, so venue was important because to choose a suitable geographical location to to try the dispute. Okay. We've been part of arbitrations where parties are from India and Singapore arbitrating in Hong Kong, but LCI, courts in London having, London being the seat, the venue merely being Hong Kong. But what Justice Nariman said, why it is important is because there are contracts which don't give a clear indication as to what is seat. So in that case, the venue will have to be mentioned. In that case, the venue will be considered to be the jurisdictional functionality of the dispute. If nothing is mentioned to the contrary, how I interpret that portion, if nothing is mentioned to the contrary, is basically that in the event there is no clause in relation to seat. So, but what he's saying is coming back to the same point. What he's saying is that if there is no express seat given in an arbitration clause, the venue will be the jurisdictional capacity of this dispute if nothing in contrary is specified. Nothing in contrary, in my opinion, is just again specifying the fact that if seat is clearly not demarcated in the dispute resolution clause. So this is the 0 of 100 of this case law. What Tariq said, I agree with it, is primarily because what Justice Nariman did was, though he might have been a bit adventurous in defining the basic essence of law, and if we go into that, we'll have to go into various other, Justice Lahoti's opinion in what was that state of Maharashtra judgment in Supreme, where a 5-judge bench was there, and then a 5-judge bench was referred to another 5-judge bench, and then the 5-judge bench would take a call whether it would be further given to a 7-judge bench, or so on and so forth. But not going into all of that, the understanding should be, or not going to any criticism of the case, what we need to understand is that determining seat is very important, because without determining the seat, the arbitration is basically non-movable in my opinion. And if we don't have a seat, okay, we need to know what it is. So in that given situation, we have to say that, let's say a venue might be the initial understanding between the parties to have been considered the seat of the given arbitration. So that is the 0 and 100 of this basic judgment. So yeah, I think we have 2 more questions on this.
One question was that what can be the other factors in addition to the venue? The additional factors, for instance, can be what was the cause of action, where the parties are situated, where the agreement was. There will be many other additional factors.
Where are the parties from?
Why is Hardy exploration bad in law? What Justice Nariman said was that it doesn't follow the 5-bench judgment in Balco, which is the larger, and therefore it is bad law. That's what he said. Antriksh and Hardy both. Because Balco said that place and seat have been used interchangeably, and that's not what has been followed.
In a case where the arbitration clause only states the venue, that is the place of convenience, and not much is stated about the seat per se, would a cause of action approach be taken then, or should the venue be understood to be the seat of arbitration subsequent to the judgment? Do you think? Yeah, that is correct, Jyotsna. What you're saying is correct. As pursuant to BGS, SGS, Soma, this is the understanding. Okay. In the event that there is no express provision in relation to what the seat is and the venue is specified, that is forum convenience, in such a situation, along with the other factors that Tariq just mentioned, it would be considered that the venue to be the effective seat of the arbitration. Urmil, this is actually a very question. BGA Soma pro or anti-arbitration. If you can, Mohit, if you can unmute Urmil for a point of time, and Urmil, you can tell us what do you think if BGA Soma pro is anti or pro arbitration. I would really want your opinion, then come to the understanding.
Sure. Urmil has been unmuted.
Yeah, Urmil.
So sir, thank you very much for this. So basically, I was also watching a video of the Justice Nariman of the GAR review of 2020, and that is why I asked this particular question, because in that particular Nariman mentioned that the BGS Soma was again a very good law because it was again in consonance with the Balco judgment. So that is why I was wondering whether this would in actuality be a pro arbitration judgment, because like sir said that this particular concept of seat and venue emerged from international commercial arbitration, and there's no basically there's no highlight of it in the domestic arbitration, and it is gradually came into being. So that is why I was also wondering that can it even be a pro arbitration judgment? Wondering if you could answer this.
In my opinion, this is definitely a pro arbitration. So anything which defeats going into arbitration and can be knit up, in my opinion, is a pro arbitration decision. Okay. In this case, in contracts where the seat is expressly not mentioned, it would have been again a position of dispute and court litigation in relation to what constitutes seat. Now, having cleared that point and saying that the venue, if nothing is mentioned to the contrary, will and if the seat is not mentioned, will act as a seat, clears up a lot of confusion in relation to this point. So this, like, I would also like to listen to Tariq's opinion, but this, in my opinion, is definitely a pro arbitration, because in my opinion, anything which clears up a roadblock to a prospective arbitration is not against natural justice, is a pro arbitration mechanism. And in this situation, it clearly takes off a hindrance, saying that if the seat is clearly not specified, the venue of the arbitration, taking into consideration other factors, not to the extent that nothing to the contrary is mentioned, will be considered to be the seat of the arbitration. Okay. If this judgment was not there, I think there would, in relation to what constitutes seat, if there's no express decision, would be a hugely litigated and disputed issue. So given that, I think this is definitely a pro arbitration decision.
I completely agree with Anubhab. I think it's a pro arbitration stance which has been taken by the court, because mostly what used to happen because of this ambiguity, almost every matter used to go to the court. Then arbitration used to get delayed, and unnecessarily there was no end to it. Everybody used to go and say, no, venue is the seat, place is the seat, this court will have jurisdiction, that court will have jurisdiction. At least for now, there has been put an end to it. And unless we can only wait how it turns out to be, but to my mind, it's a good, and there is more clarity on law now. And unless the debate is settled by a 5-judge bench, we still have.
I think we've received another question from Kajal Gupta. In case of domestic arbitration, any choice of venue could be interpreted as seat if there is no contrary mentioning. And if venue is the place where the hearing is held, would it be advisable not to mention the venue at all in an agreement? What are your thoughts on that? I think that's an interesting question.
Yeah.
You want me to answer that, or what is asked?
Yeah, go for it, Tariq. Yeah, no problem.
See, the thing is that if I am entering into an agreement, that's my view and that's my understanding. As long as I'm defining the seat, I'm safe, because like I said, seat is the epicenter of an arbitration.
Correct.
And so far as I'm mentioning the seat to be Delhi, for instance, then Delhi courts have exclusive jurisdiction. Venue may be Taj Mansingh, venue may be Delhi International Arbitration Center. I can always write that, the arbitration will be conducted under the aegis of DIAC, which is Delhi International Arbitration Center, or for the venue keeps changing in that case. However, if there is no mention of the seat, then that is when all of this comes into the picture. As long as you are defining the seat, the intention is clear of the parties that where they want the exclusive jurisdiction and what courts will intervene. So there is no problem even if you mention about the venue, to my mind.
If there are any further questions, you can direct them right now. You can just put them on the chat. You could even raise your hand and we'll possibly...
I think now you can unmute all. We can take 1 or 2 questions. Unmute all and just...
Sure.
Somebody want to speak? Should I unmute?
Right. So everyone's been unmuted.
Just raise your hand first. There's an option to raise your hand, and then you can ask the question because,
Yeah, we can have 1 or 2 questions if they want.
Any questions, or even if you want to discuss, I suppose.
A lot of people might be very lazy. Nowadays, everybody is lazy. Maybe they don't want to type that much.
If I may get the ball rolling then, it's actually interesting that Anubhab Sir puts it that BGS Soma is a very good law indeed. However, the issue, I suppose, is the manner in which Justice Nariman has sought to bring this about. I think Urmil referred to the GAR live session with Justice Nariman, wherein Justice Nariman had himself conceded that when he was writing that judgment, hardy exploration was an issue, seeing that it was given by a bench of the same strength. So I suppose, knowing Indian litigants, I suppose the consensus to this issue can only be raised once we have a 5-judge decision, because it's bound that BGS Soma will be challenged. Do you guys think so? Tariq sir and Anubhab sir, if you would want to take that up.
On the challenge of BGS Soma, it can be, in my opinion, you can't indicate the reasoning given by. I think, in my opinion, it is very hard to eradicate the reasoning given by justice. You might be able to eradicate the, like I said, on steroid diseases and all of that, you can eradicate it. But it would take a huge debate on that to happen. And that would, again, turn out to be a very, very landmark decision. So far, nobody is touching this, in my opinion, because everybody understands that this law is precisely very straightforward and crisp to the point. At least it solves a lot of problems. But of course, it can be challenging. Challenging anything.
तो ठीक है बंद कर दो.
I suppose with that, seeing as we don't have any more questions coming in, what we can possibly do is, if you have any questions, right?
We can just be around for 5 minutes. If anybody has any questions, we can take it. Otherwise,
with that, however, I suppose, okay, I see we've got another question coming in from Sonali. I'll just send that across. But yes, in case anyone wants to leave, I suppose we are done with the session. So conclude, I thank you all for coming to this session. I understand. I suppose we were a bit conservative with the time allocation for each case, but it's heartening to see everyone participating so extensively. We've had a flurry of questions coming, and I thank you all for participating. We've got many more sessions coming up. We'll have three more sessions on the 11th, 13th, and the 15th. On the 11th, we'll have a session on LLM in arbitration. Is it worth it? And also, what are anecdotes of individuals who've gone outside and pursued these LLM courses? Perhaps you'd want to join in there. The third session that we'll again have Mr. Anubhab Sarkar. Anubhab sir will be dealing with the fair and equitable treatment under investment law. And Anubhab sir has a lot of experience in investment law. He recently represented an Indian conglomerate against a SARC nation in a BIT claim. And he has immense knowledge of investment law. And I'm sure that if you attend it, it will be worth it. We'll have Mr. Tariq Khan joining us again in the second half of that session, and they'll be speaking on cross-examination in arbitration. For the fourth session, we'll have something which is not particularly related to arbitration, but it is on international law. Anubhav sir will be talking about whether there can be any attribution of liability to China in light of the COVID-19 pandemic, which I suppose will be of interest, seeing the recent criticism that has been generated against China. So do join us for that. The links will be, you could visit our social media handles. The links are there. You could go to our blog, which is rtnalcadr.wordpress.com, and you'll have access to the registration link via there as well. So we hope to see you over there, and we thank you for turning up. As again, the questions are open, so please just send them in.
Nobody has any questions?
I think we have a few. A few have been coming in. We have this one from Sonali. Another interpretation by the tribunal could be completely reject the application of BGS with respect to Section 22 and Section 23. As in the present case, parties had chosen the venue, whereas in the absence of any choice with respect to seat or venue, the tribunal is at liberty to determine the seat and venue in accordance with 22 and Section 23. Perhaps we could, Sonali, you've been unmuted. Perhaps you could like elaborate on this more and we could have a discussion. We've also had another question from Shubham Jaiswal. If seat of arbitration is Lucknow, that is all proceedings have taken place in Lucknow, and suppose a party is not satisfied with the judgment, can they file the appeal in the district where the original contract has taken place? Maybe Allahabad. I'll send the judgment.
For the people who are asking the questions, can they just speak up considering everybody has been unmuted?
Sonali, if perhaps you would want to take up your comment. I suppose not. It's
Okay.
muted.
No
Okay,
problem.
I'm not too
No
sure
problem.
how that's happening.
The last question I don't seem to understand. I don't know if Tariq, you've understood.
See, I can try to answer on my understanding. Seat of arbitration is Lucknow. So if seat of arbitration is Lucknow, then you cannot go anywhere else. You have to file it in Lucknow. Anything else is irrelevant because you're saying the seat is defined as Lucknow. Whether original contract was entered into in Allahabad, etc., it is irrelevant. So, and furthermore, if party is not satisfied, this is now not how it happens. When parties decide that this place is going to be the seat, they can't keep changing it as per their convenience. Any other questions? Okay, regarding 23 also you want me to answer? The other question by...
That was more of a comment, but I think like we'd love to have a discussion on that.
I think, yeah, there's less clarity on the question, but I'll just tell you what I infer from this. So this person is assuming that A, there is no seat, B, there is no venue agreed by the parties, the place not agreed by the parties, and then the arbitrator is free as per section 20. Yes, arbitrator can decide if there is no agreement between the parties, then arbitrator will decide where to conduct the hearings, where to cross-examine the witness. All of that I mean, it's a hypothetical situation. So far, no such case has come. But at the end of the day, like I said, if the parties have not agreed on any of these things, place or venue or seat, anything, and if they have not mentioned about any jurisdiction, generally what they do is they put a jurisdiction clause. It happened in one of my matter. Apart from the arbitration clause, there was a jurisdiction clause that the courts alone in Delhi shall have jurisdiction. The courts have the practice, if you read the judgment in Brahmini by Justice Bhanumati, and there is another judgment of Delhi High Court, all these questions will be answered in my matter called Kalp Taru versus IOCL. Kalp Patru. So if you see that it's a last month's judgment, law has been very nicely discussed on this point, and all possibilities have been discussed. So you would want to read more further to get more clarity.
I think we have Sonali with us.
The drafting of an arbitration clause, I think, is a question for. It can be. We can take a day to discuss that. But what I can do is that I can maybe send you an ideal arbitration clause. I can send it via WhatsApp to Mohit, and Mohit can maybe share it here.
Certainly, we can do that. What we can also possibly do, since Anubhab sir is extremely keen on having practical courses as well, perhaps we could have another session on drafting of arbitration clauses. I know Anubhab sir is involved in a lot of transactional work, so perhaps we could have something on that end as well.
Yeah, sure. I mean, we can do that with the part. We can do that on the next day only. We can start like half an hour before, and yeah, we can take it up from there.
I
Maybe
think so.
Tariq can also join us for that, like if he's free.
Done.
I think then what we can do right now is we'll forward whatever resources, we'll send via email a sort of brief minutes of whatever has happened, all of the cases that have been discussed along with the 3 cases, as well as any other ancillary material that Anubhab sir or Tariq sir will send to us right now. And if we're good, then I think we can call it an end. I think this has been a successful session, and we can end it on a positive note.
Yeah, sure.
Right.
Yeah.
Very well. Thank you everyone for staying with us. Please do go ahead and check the other sessions that we'll be having and register yourself for them. Thank you, and goodbye then.
Thank you, everyone. Thank you.
Cool. Thanks, guys.
Thank you, everyone.
Mohit, can you just share the email address, or where can I share this arbitration clause with?
You can send that across to me, and we'll send it across to the participants. We'll CC you and Tariq sir on that.
Okay.
Have a compilation of all the email IDs.
Okay, guys. Thank you so much. It was a pleasure. Please stay indoors, and yeah, don't go out and don't do anything which would be detriment to the whole cause.
And be productive.
Be productive. Of course, be productive. Stay safe, guys. Stay safe. Take care of yourselves, guys. Cheers. Bye.
Bye-bye.
Let's play Tariq. Let's get on Call of Duty.
Yeah.